Good morning. Thank you everyone for being here with us today. We wanted to give a special thank you to the International Institute of Space Law for hosting this colloquium, and to the Global Networking Forum and the International Astronautical Federation for having us here and hosting us today. We'd also like to give a thank you to AIAA for a great week here at the IAC. And of course, I would especially like to thank my panelists and my co-moderator who are up here on the stage with me here to speak with you today. As you can see, this is an entire panel of NASA attorneys. However, the views discussed here today will be our own and do not necessarily reflect those of the US government or the National Aeronautics and Space Administration. My name is Jessica, and I'm an attorney with Goddard Spaceflight Center. My focus is on government contracts, fiscal law, interagency, and Space Act agreements. My first panelist here is Ms. Christine Pham. She is an attorney with NASA Ames, who is currently serving as Directorate Lead Counsel with the Human Exploration and Operations Mission Directorate at NASA headquarters. Next, we have Bill Johnson. Bill is an attorney with NASA Glenn Research Center, and his practice focuses on patent prosecution and intellectual property issues, such as IP licensing and data right negotiations. Next to Bill, we have David Lopez. David is an attorney at NASA headquarters, and he focuses on international law, including export control matters, planetary defense, and space law-related matters. Our final panelist is Brian Stanford. Brian is also an attorney at NASA headquarters, and he is a member of the Government Contracts Group, focusing on federal procurement law and litigation, including the ISS commercialization efforts. And last but absolutely not least is my co-moderator, Ms. Lizette Washington, and she is also at NASA headquarters, focusing on government contract, including bid protests, business contracting, procurement policy, and contract administration. So thank you to you all. We're looking forward to having this conversation today, and I'm going to turn it over to my co-moderator, Lizette, to lead us off with an introduction.
Thanks, Jesse. Good morning. As Jesse said, my name is Lizette Washington. Today you will hear from this panel of next generation attorneys who are playing a crucial role as NASA continues to lead the world in space exploration and now take on this exciting challenge of paving the way to the moon and onto Mars. The Artemis Program is NASA's next step in human exploration, which involves all lunar activities and, in particular, putting the first woman and the next man on the lunar South Pole by 2024. With the Artemis Program, NASA will demonstrate new technologies, capabilities, and business approaches, and NASA will then use what it learned in Artemis to send astronauts to Mars, hopefully by 2028. Today, you will learn from the panel about the legal framework and legal instruments on which the Moon to Mars endeavor heavily depends, as well as important legal questions that involve unique contractual, commercial, intellectual property, and international considerations. The panel will also discuss NASA's efforts to incentivize and encourage commercial and international partnerships in order to achieve smarter and more efficient technologies that will accelerate the Artemis mission and establish sustainable lunar exploration. And finally, the panel will also discuss with you how their role as legal advisors are changing as NASA evolves to take on these future missions. And as Jesse said, there's the disclosure that the views and opinions expressed by the panelists are their own and do not reflect the official position of NASA or the government. So let's get started.
Thank you, Lizette. To get us started for our first question, I'm going to ask our panel to please give us a brief introduction of NASA's current Moon to Mars endeavors and the associated programs and legal instruments being used. And to kick us off, I'm going to ask Christine.
So we heard from our NASA administrator this week. We are going forward to the moon and then to Mars, and we will do so sustainably with our commercial and our international partners. So let me give a brief overview of the types of activities going on right now in the Human Explorations and Operation Mission Directorate, and also a brief just introduction on the legal instruments that are currently in use or will be anticipated in order to carry out these endeavors. Starting with low Earth orbit, the ISS has been a successful collaboration for more than 2 decades, providing a continuous human presence in low Earth orbit and a microgravity research platform. The ISS has been implemented through different types of agreements, including a 3-tiered international agreement with the IGA, the Memorandum of Understandings, and the implementing agreements that David will talk about further. Operationally, we are able to conduct these activities through government contracts utilizing FAR-based contracts, and FAR under this context is the Federal Acquisition Regulations. In June, NASA also announced an interim commercial use policy to catalyze and nurture emerging LEO commercial markets. These particular activities are anticipated to be implemented through government agreements such as the Space Act Agreement or contracts. 3 broad agency announcements were also released in the last several months in order to stimulate commercial activities, including one for the stimulation of demand through applied research, one for the ISS commercial ports, and one for the commercial free flyers. All 3 of these have been issued under the broad agency announcement called Next Step, which is a public-private partnership model where we are looking to accomplish commercial development of deep space exploration capabilities, allowing NASA to also have and meet our exploration objectives, and also allowing commercial industries to be supported and to meet their own commercialization plans. All of this, of course, is in addition to our ongoing efforts to enable the commercial launch sectors through the Commercial Crew Program and Commercial Resupply Services, both of which are traditional government contracts. Moving on to deep space transportation, the powerful Space Launch System will carry the Orion spacecraft beyond the vicinity of low Earth orbit for the Artemis mission. Artemis 1, we are working towards a 2020 launch date for the first test flight of the SLS and Orion as an integrated system. For Artemis 2, we are looking at the first flight of crew to the vicinity of the moon by targeting for 2022. And then by 2024, as Lizette has mentioned, NASA will land astronauts on the moon through Artemis 3. Both the Space Launch System and the Orion are conducted under traditional government contracts. The Gateway will be a lunar orbiting platform that will serve as a departure point to the moon and potentially for Mars. The first element, the power and propulsion elements, was awarded this spring under a broad agency announcement as well. The second element, the habitation and logistic outpost, was awarded under the Next Step broad agency announcement. Last, the Gateway Logistics Services solicitation, a contract that will deliver service and supplies to Gateway. It's currently underway right now, and that's actually being conducted as a FAR Part 12 contract, which is for commercial services. Last, in order to get to the surface of the moon, and Brian will speak to this more, NASA recently issued a solicitation also under the Next Step broad agency announcement for the human landing system. That was announced on September 30th with the proposals due later this month. So I'll pause there.
Thanks, Christine. And over to Lizette.
Yes. So as NASA works on the Moon to Mars missions, what are some of the guiding legal instruments? Christine mentioned a few, both domestic and international, that are being utilized. And if Brian, if you could get us started on that question, and also what are the risks and constraints with using those instruments?
Certainly. Thank you, Lisette. So I guess we, as a government agency, have traditional mechanisms and instruments, and the choice of instruments obviously depends on our authority, our consistency with internal policy, and with a meaningful examination of the reason for the instrument, who's benefiting. And so, at least in the Artemis program, we are not, I would say, we are being very creative in the use of our instruments. However, I would caveat that by saying, in some ways, we're not really doing anything new. We're building on transactional models that were established over the past 2 decades from our previous forays into partnering with industry to develop spaceflight transportation capabilities with the ability to use them in space and advance NASA's programmatic goals. And so previously we have provided funding in order to fund the development of these capabilities in order to retire technical risk for the contractor or for the entity doing the development, and doing so will hopefully bring down the industry partners' risk profile and help them close their business case, so that when the technology is sufficiently mature enough to be used by NASA, NASA will be one of many customers of those technologies. And so previously, on some of our low Earth orbit commercial space transportation efforts, we have funded development through first Space Act agreements using our Space Act authority, and then later by traditional FAR, federal acquisition-based contracts for procurement of services. The broad agency announcement is, I call it kind of the best of both of those worlds. It still results in a traditional FAR-based contract, but what's special about it, and I think Christine touched on this, is that it is a procurement instrument for the competitive acquisition of R&D, and it allows us to have a little bit more flexibility in how we look at different industries' proposed capabilities. There's a lot of differentiation amongst industry about how to do things. So we're kind of, again, as we've been doing over the past 2 decades, moving away from the paradigm of NASA-directed, NASA-specified design and development, and moving over to contractor-led development. So we're going to be providing much less direction, much less specification, and relying on industry to develop their own solutions that meet our overarching needs and get to a place where we can certify NASA's use of those capabilities. So the broad agency announcement is a solicitation mechanism to compete those development activities. It has some of those features and the flexibilities I was discussing of Space Act agreements without having to stagger parallel contractual efforts, which we've done in the past. And it also gives us the flexibility to evaluate the merit of each proposed partner's technical solutions for some of these capabilities, because there's a lot of differentiation about when you talk about contractor-led development in how to solve the problem. And so it really gives the agency the ability to look at each idea and judge its merit and how it helps enable NASA's goals. So a little bit about the broad agency announcement process. As Christine also mentioned, the ultimate goal here, the end goal for the agency, is to acquire space transportation services through commercial means as commercial services. And so we've effectuated that model through cargo and crew transportation to the space station, and we intend to effectuate that model when it comes to resupplying Gateway and providing lunar surface transportation services to NASA astronauts.
All right, thanks, Brian. And David, what about the international instruments?
Sure, thanks, Lizette. Good morning, everybody. As some of my panelists have spoken to the domestic side of things, there's also an international component to everything that we do as a government agency. And I'll just give a brief overview of the 5 outer space treaties. First, we'll start out with the Outer Space Treaty itself. And as many are familiar with it, it's also considered the Magna Carta of what space activities are. But interestingly enough, it's actually a very short and brief treaty, and that was designed on purpose, because in order to have it be passed by consensus, it needed to include a lot of things, but also did not say a lot of things, which I'll get to later, because that becomes a constraint as to, well, what can we do in outer space? Moving on, then there's also the Liability Convention that is there to apply in situations of damage caused by a space object, both on Earth and in outer space. And there's 2 different schemes. And moving on, there's also the Registration Convention and the Rescue Mission, the Rescue Agreement. And the last one out of the 5 is the Moon Treaty, which does not have consensus and is not considered to be, as the other 4, a legal instrument that a lot of countries follow, because in fact a lot of spacefaring nations did not ratify that agreement. So that broadly, those are the 5 outer space treaties, and NASA does all of its activities consistent with its obligations under the Outer Space Treaty. and including everything we will be doing with Artemis and moving forward. What I mentioned earlier was, and what Lizette's question gets to, is the legal constraints. It's very difficult when they were doing the Outer Space Treaty in 1967, if what could be considered an activity that couldn't be contemplated, say, 50 years from now, and that's what we have today. A lot of the drafters did not consider things that are happening currently, and that makes it really hard to read something that is not there in text. Now, for us as lawyers, that makes it difficult, but also interesting for our job, because we have to wrestle with, well, what can we do and not do? And so that's something that we're seeing on the international side, and as many of you have been here at IAC, know that there are a lot of conversations and discussions on some of these activities, which we'll talk about later. But certainly that's a constraint from the international side, and it's something that we collectively, as practitioners of law on this stage, are wrestle with, because we have a lot of things that we want to do as an agency, and we also need to make sure that we can do it and do it consistent with law.
Said I have one go back because I forgot to answer your question about constraints and risks.
No worries, please share.
So I think part of our role, and I think David touched on this in his practice area, is to be creative while operating within the bounds of our treaties, statute, regulations, and the same is the case in our contractual mechanisms as well. We're obviously constrained by our regulations, and we have to be creative on the contract side of the house, drafting specialized terms that enable a more hands-off approach, as I talked about earlier, while still preserving an appropriate level of insight and oversight of contractor-led development. And we, as a government agency, are obviously, unlike private industry, as commercial as we say we want to be, still have to comport with rules of fundamental fairness and how we compete these efforts. These are highly competitive efforts, and it's why we as the legal team are so instrumental in helping establish a comprehensive, robust, and fair competitive process, and making sure that model is adhered to. So,
Thank you both.
Yeah. Thank you, Brian, and thank you, David, for giving us that overview of both the domestic and international landscapes. One area we haven't touched on here yet is the intellectual property ramifications. And so turning to address that, Bill, if you could discuss with us in regard to IP and patent law, what is the traditional legal framework related to data rights, technical data, and inventions?
Thanks, Jessica. Before answering that question directly, I think it's useful to kind of step back here and just kind of like look at it from the technical perspective. This is an extremely broad undertaking. What is going on, requiring a lot of investment on NASA's part and from our partners to achieve going to the moon and then Mars, right? It's going to require a lot of technical capability that we might not necessarily have, and so given the costs and the associated risks with such instruments, IP is going to play a crucial part. Any time any entity wants to protect its interests in the future, intellectual property rights in the technical realm is going to play a huge role. And with more and more commercial entities playing a larger role in this context, and given the fact that intellectual property laws is a primary mechanism through which they can protect their investments, we're seeing IP play a larger and larger role in this context. And so I think in the context of extremely advanced R&D, and that's ultimately what this is, what a lot of the stuff that's going on with all this, it's kind of useful to think about it from how, compare and contrast how two commercial entities contracting to perform such work would behave to working with NASA. So under American law, there's kind of a blank slate from the commercial perspective. Companies can come up with rights regimes largely to their choosing with respect to IP. They can formulate complex sort of assignment schemes for inventions developed under R&D contracting activity. And for advanced R&D, right, if something's not going to fly off the shelf into the market, they're going to largely want to operate in a sort of largely confidential realm with respect to technical data. They don't want their partners publishing things. They want to keep things under wrap until they go to market to protect their market positions, right? So private entities conducting these activities would largely formulate their own framework that's largely contextual given the technical stature of the parties involved, right? Kind of like moving to NASA now and conducting these activities, it's different, right? We have a statutory framework that has features that are non-negotiable. As an attorney, I'm not going to go against an enabling statute of my agency, right? So there's some things that are set out that are kind of pre-canned that we can't negotiate away. And as what Brian talked about, we're operating under the FAR, we're operating under a lot of regulations that detail a lot of frameworks that are mandated when certain activities are being conducted, right? And so kind of just like going into sort of like the unique sort of nature of NASA statute, with respect to inventions, NASA is kind of a unique government agency in that it's a so-called title-taking agency. And basically what that means is R&D contracts, a contractor performing activities for R&D for NASA, NASA automatically vests title in any inventions arising out of that work. So it's kind of like, contrast that with the commercial perspective of being able to formulate any sort of assignment mechanism that you would like. The automatic sort of presumption for large entities anyway is that for R&D, the title vests in NASA, and we'll go into this a little later. The contractor can request waiver from NASA, and we have detailed waiver regulations about procedures that can be followed to potentially give, if the case warrants, title back to the contractor. And we'll talk about a little bit about later about how we're using that framework to be more flexible with our partners. And so that's kind of set in stone. It's a little bit, one more complexity is the Bayh-Dole Act, which the actual clause used depends on the size and nature of the entity we're dealing with. So large business entities, the title-taking regime still in place. The Bayh-Dole Act in 1980 kind of changed the framework for small entities and universities where instead of NASA taking title, the contractor gets 2 years to elect title in the invention. So it's a little bit different regime for each, depending on the instrument used and what type of contractor you're working with. With respect to technical data, right, like what I said before, for advanced R&Ds, a lot of private entities, if they work together in such activities, would want to keep things under wraps for as long as possible under non-disclosure agreements or such. The Space Act is pretty clear, absent like national security or other exception applying. A lot of things that data that NASA obtains or produces in the performance of its activities is available for public inspection public inspection. So we are limited in the certain types of things that we can keep under wraps forever, right? That's just inherently in our statute. That's kind of like part of our beast. So that's very different from sort of the private contractual realm. And you know, about technical data that we would produce in these activities, kind of like the standard framework is if you use government money to produce it, NASA gets to do whatever it wants with it. And anything developed at private expense outside of the agreement, NASA is obligated to keep under wraps. There's some flexibilities that we'll talk about later that we're leveraging to incentivize commercial involvement, but that's kind of like the basic sort of framework.
All right, thanks, Bill, for sharing with us the technical considerations as well as the Bayh-Dole Act and NASA as a title-taking agency, and then giving us an appreciation that NASA understands that the private sector or industry is concerned about, you know, what would happen with their intellectual property under the legal instruments that we just discussed. So there are limiting constraints that the government or that NASA has as a government agency, as we shared with the legal instruments, the intellectual property considerations. So Brian, if you could get us started with how NASA is doing things differently in order to incentivize the private sector to participate and maximize contractor-led development.
Certainly. Thanks, Lisette. I think Bill's topic is a perfect lead-in for this because I think it's such a great example of trying to shift the paradigm and support this public-private partnership model And data rights and IP, I think, are obviously, they're big money, and they are very important as technologies are developed under these efforts. And so changing that paradigm takes work and takes creative lawyering, but we have been revisiting the rights that the government takes in data first produced under the contract in some of these efforts. We are trying to establish what I would term kind of a middle path that incentivizes industry participation, encourages that private development, gets industry to put skin in the game, while also sufficiently protecting both NASA's and the industry's intellectual property interests in the effort. And the other area in the intellectual property arena that I think is worth talking about a little bit more is, as Bill was saying, advanced waivers of inventions, patentable inventions produced under the contract. I'm going to leave that to Bill to get into the nitty-gritty, but it's like such a good example of how we're trying to do things differently. What can we do differently and creatively as lawyers? I mean, there's a huge list of how we're trying to revisit some of these contractual issues for these efforts in order to stimulate a public-private partnership model. We're rethinking a termination when the government can terminate a contractor's contract and what the remedies are. We're rethinking how contractors get paid over the course of the development effort, and does that payment scheme shift depending on the stage of the development or demonstration or other action of the contract. We're rethinking our cross waiver of liability, and Christine will touch on that a little bit more. We're rethinking the amount of insurance that we require contractors to acquire for these efforts. And we are rethinking how NASA makes its own capabilities and resources available to industry to support these efforts. All of these things take a ton of creative lawyering, and that's my shout out to our entire NASA legal team, because I think when we work together, it's some of the most creative and hardworking lawyering I've ever seen done before. So again, it's up to us to listen to our stakeholders and hear their desirements about what they want to do differently to incentivize, and then help them formulate a strategy to meet those desirements if we can, and advise them when their desirements are not advisable, and then drafting the particularized contractual terms and policies and other language that are necessary to effectuate the doing things differently. So.
All right, thanks, Brian. And then, Bill, on to you for the nitty-gritty, and we want to also understand the advanced waiver.
Yeah, so there's kind of like two tiers to the whole title-taking thing. I mean, so there's one, whether it even applies in the first place to the certain contractual context you're dealing with, and there's the second is, if it does apply, how do you sort of work within that framework? So taking the first one, right, if it applies in the first place, I think now that we have a focus on intellectual prop, we're really focusing hard to be creative within the legal community at NASA. And so sort of whether it applies or not, in a lot of sort of Space Act agreements or like mixed funding arrangements potentially we have, there's sort of a framework we can talk about where whether the R&D is being conducted for NASA, being more specific about programmatic requirements that are being met through the performance of the contract, and whether that applies or not. Being more clear about that is helpful to partners, knowing in advance what work is going to be fulfilling NASA's programmatic requirements and when the title-taking provisions will apply. So that's just kind of like one helpful sort of thing that I think you're going to see. And another is within the framework itself. Brian mentioned advanced waivers. So sort of like the typical sort of way it works is there's, under the patent rights clauses in the various agreements, contractors are obligated to report any inventions that are developed under R&D activities, and then after sort of the invention, they can request a waiver as the inventions are made, and that goes to something called the Inventions Contribution Board at NASA headquarters, and they decide case-by-case basis whether to grant the waiver. So the advanced waiver allows the partner to pre-delineate a specific class of inventions that NASA would agree to that would go up out to the board, and they would grant in advance. So by using these advanced waiver instruments and terming those sorts of classes of inventions well, it again provides the partner with more clarity up front as to what sorts of IP rights they can expect to get out of this arrangement.
Thank you, Brian, and thank you, Bill. And being mindful of our time, I'm going to move down to our next topic and get into the discussion on commercialization. So if I could turn to our panelists and ask, what does it mean to be commercial in low Earth orbit, and in the context of the lunar lander and other mission-related programs? And I'll turn that over to Christine to start us off.
I think when we're looking at it, commercial means to open opportunities and catalyze the industry. I think part of NASA's role, especially in our technical and science community, their main, and one of their main things is to help retire technical hurdles. How do they, for example, help identify some of these risks through technologies in order to ultimately retire those risks, which will ultimately translate to driving down costs for companies. And when that happens, then companies are able to better scale their business models. And I think, because we're a panel of attorneys, as we shift to commercial, we also have to start thinking, especially like Bill mentioned, we have our government constraints, but commercial sectors and commercial partners, they also have commercially reasonable norms. Like, for example, when we're looking at risk managers, right? We're looking at how do we manage risk? How do we handle insurance and liability? Now we're going to be looking at it from both the government's experience, but also as we move and work much more with commercial partners, how do we do it in a way that properly allocates that risk to the commercial sectors? Brian, you want to add anything to that too?
Yeah, no, that's a really good intro. I think to answer the question, Jesse, that it depends on the effort. What is commercial? Recall again, we have a statutory mandate as an agency to encourage, to the greatest extent possible, the fullest commercial use of outer space. I consider that a pretty strong mandate. And again, we have previously set up a commercial model for crew and cargo transportation services to the space station in LEO. And in the past year, and Christine will help me elaborate on this, but the NASA legal team has been really involved with helping the Human Exploration Operation Mission Directorate and the ISS Program Office find what that line of commercial activities that we as an agency can sanction on ISS as well as in LEO generally, and help them establish a policy that enables those commercial activities and figure out a way to define what commercial activities we can help facilitate and support. And really, it's those activities that advance a sustainable LEO economy, contemplate commercial application of the space station's unique microgravity environment, and that otherwise have a nexus to NASA's mission. And so helping our clients draw those boundaries in an attempt to set up a meaningful policy has been quite a challenge, but a lot of fun to work on. And I think policy creation such as this creates all kinds of legal considerations. Obviously, we have to figure out how we make commercial opportunities available to interested firms in an equitable manner. We have to figure out how NASA can support these activities without running afoul of ethical restrictions and other prohibitions. We have to figure out how we commit agreements with commercial partners to writing. And we have to figure out how NASA can permit these types of activities while staying true to the agency's obligations to its international partners, which I'm sure David will touch on. So I think, Christine, you have more to say about our ISS commercialization policy.
Yeah. Sure, we can jump right into the ISS commercialization. Go ahead.
And I guess just kind of wrapping up the previous question, the goal of that is so that NASA ultimately can be one of many customers. And NASA does have a history in terms of supporting commercial markets. Like, for example, in our aeronautics research, much of our science research and outcomes have led to a very robust U.S. commercial aviation industry. So, we do have a really strong history of doing so, and I think this is the next endeavor. So earlier I had already mentioned that we had the 3 broad agency announcements for low Earth orbit commercialization. That was under the Next Steps BAA. In addition to that, earlier this year we had introduced a 5-step policy to meet our mandate of LEO commercialization. And just diving in a little further for the commercial use policy, as Brian and Bill had mentioned, we have these authorities, and this particular use policy was entered into under our existing authority, so utilizing what we already have in order to enable these activities to occur. In order one of the main reasons for doing so and having a policy is so that we can provide some certainty to industry about what they can expect so that they can actually build their business plans. With the use policy, you can find it online. Companies can submit their proposal, and NASA will evaluate it to determine whether or not it falls within our existing authorities. These types of activities could include manufacturing, production, transportation, and marketing of commercial goods and resources. And I think Brian already touched on the 3 requirements, actually, that we would like to see, which is, do these activities require the unique microgravity environment? Does it have a nexus to NASA mission? Does it support the development of a sustainable low Earth orbit economy? 4th out of those 5 policies at this point, NASA also announced the intent to allow companies to fly private astronauts. And of course, there are a lot of liability and risk considerations that we're working through in order to enable that to happen. And then last, NASA also issued a white paper which provides some quantification of the agency's long-term needs in LEO. Again, that's so that we can provide some certainties to the market so that companies can actually build scalable business plans. So I'll stop there.
All right, thank you. Moving on to the next question, we've briefly touched on liability. We're going to dive in. Now, what are the current issues regarding liability and cross waivers? This is for Brian and Christine. Can you start explaining the International Space Station Intergovernmental Agreement? That's a mouthful, but we call it the IGA cross waiver and other liability considerations.
So I'll give a really high-level overview of this, only because this probably could be its own panel. But just to kind of go over it, and then I'm sure David and Brian can chime in as well. The IGA currently requires that the parties to the agreement flow down their cross-waiver provisions to their related entities. So a cross-waiver provision in this sense is that, hey, will you require the parties to waive claims for damages against the related entities? The definition is much more, but for example, those would include folks like your contractors, your subcontractors, and their suppliers at any tier. The types of damages that are contemplated are damages for any damages that flow from damage to property, injury or death, or types of business damages such as loss of revenue or profit, and other consequential and incidental damages as well. In addition to this cross-waiver requirement for a partner entity and their own contractors, NASA also extended a reciprocal cross-waiver to our contractors to also waive claims between our contractors and NASA. That's not required from the IGA, but that has been a deviation that has been included in our contracts related to date, starting with the commercial crew. Lunar surface operations, on the other hand, if you were in the head of space agency's conversation, I think that was Tuesday or Monday, lunar surface operations are not included as a cross waiver under the IGA. So because Brian and Allison had to work on the human landing systems, we had to work on a clause for that particular solicitation. But a lot of that is informed and designed based on the legal framework that we have been used to and we have been working under the IGA. So I'll kind of stop there.
Is there anything else you wanted to add, Brian?
David, do you have anything? I guess I would just to pile on, I think this is a really good example of creative lawyering and working contract terms and conditions that help enable these activities. Again, as Christine mentioned, we've been using this reciprocal waiver between the government and our contractors on our latest forays into spaceflight transportation capability efforts, and Artemis is no different in that respect. And so again, these are hazardous activities, and in order to help incentivize industry participation, that reciprocal waiver is we find very, very important. One caveat, one lawyer caveat, per the terms of the clause, the cross waiver of liability for damages does not impact our agency's rights under each contract with the contractor. So if there's an issue with the contractor's performance by the terms of the contract, that's not governed by the cross waiver. So.
And maybe one more thing to add to that, and it also requires financial insurance or capability as a consideration for the government waiving waiving its rights for damages, and the activities have to be, of course, protected space operations as well.
That's right.
Thank you, Brian, and thank you, Christine. We're getting close to our time, and we'd like to leave a few minutes for audience questions. So I'm going to ask a final question on international law, and then turn it over to my co-moderator for the final question for our panelists. So this one is for you, David. Can you discuss the international bodies that are addressing the Moon to Mars efforts?
Sure. Thanks, Jesse. So what we've covered a lot today is a lot of ground on the internal agency decision-making process, but there are actually a lot of external bodies that are working to facilitate a lot of Moon to Mars efforts. The most obvious would be the UN, right? They have an outer space office that actually puts out a lot of guidelines and principles that convene every year, and they put these out, and a lot of them are essentially trying to get at what are the norms and the behaviors that we want to have associated with future Moon to Mars efforts. And a lot of those have to do with sustainability, right? We want to make sure that a lot of these efforts are sustainable, and that is consistent with NASA's own Artemis program. We want to go back to the moon, but we also want to have a sustainable presence, right? We just don't want to go back and then you know, not and only be there for a small, short time. And sustainability is a really big thing that the Outer Space Office is looking at. We also have consensus bodies, right? They don't have any regulatory decision kind of power yet, but they are actually very important in ways in which we conduct our behavior. I'll mention just briefly COSPAR that deals with planetary protection issues. That will be very essential for future Mars and then more deep space missions, right? Because essentially, a lot of the things that we're going to be wanting to do on other celestial bodies is science, and we want to make sure that those things are adhered to, and that comes right out of the Outer Space Treaty, and where the words are, you know, we do not want to have harmful contamination, both forward and backward, and so those bodies kind of came out of that, you know, that simple language, and so that's a starting place. The one thing that I think I just want to touch on too is that it's very difficult at the international level to have some kind of regulatory body to do a lot of things. We know that if any of you are familiar with the Moon Treaty, the reason why that did not get consensus is because it called for creating a regime that would regulate how, you know, to do activities and resources on the moon. That was very difficult to envision then, and it's difficult also now to envision something like that. But what works are consensus-building bodies that help shape behaviors and norms. That's one starting place, right? It's very difficult to think of something where a lot of parties would agree to, but those are a starting place, and NASA and the U.S. have a good presence and involved in a lot of these committees, both on a technical side and a lawyer side, to ensure that everything that we're trying to do for our missions are consistent with existing bodies, but anything that going forward, we want to make sure that they consider the things that our expertise as an agency over the past 60 years has.
All right, thank you so much, David. So we've talked about legal instruments, we've talked about commercialization, we've talked about technical considerations, we've talked about international treaties, and overall we've talked about the constraints and risks the government, or NASA and the government, are considering, and then creative uses of our authorities, of our instruments in order to achieve the mission. So now the final question for our panelists is, what's the traditional role of NASA lawyers with regard to mission-related activities, and how is that unique role changing as the agency is evolving to meet these endeavors? And Brian, if you could, or if each of the panelists can give a brief statement to that end.
Just being mindful of our time, brief statement.
The Artemis program is the lawyer full employment program. It keeps us all extremely busy, as it is a top programmatic priority for the agency. And I think we've touched on this throughout this panel. All of us, we have to be very creative in how we address these issues as they come up. Our clients are looking to us to help them find a path forward and to lean forward as legal advisors in order to help them achieve their goals. And so it's really important to work closely with your clients, advise them on what is a good idea and what's not a good idea, and be as forward-leaning as we can. And we need to be solutions-oriented and willing to keep up with the fast pace of these programs. Obviously, it's very apparent that we're returning to the moon, and we're going there very quickly, and we're going there sustainably. And so those two dual mandates will require a lot of creativity from our legal community, as well as the ability to kind of keep up with the fast pace of events. So we need to move as fast as the program is moving.
Sure, I'll be brief, Jesse. I think, what's the role of a NASA lawyer? Well, I think we're translators at heart, right? We have clients that are highly skilled technical, scientific individuals, and what I see as our job is to translate something that they want to do and accomplish, and then think, how can I apply that, and then make it sound like a legal argument as to what they want to do, and allow them to do their job, right? So being able to translate what we're hearing and then put it in some kind of legal document or effectuate that somehow from the legal side, I think is critical, because that's something that they really have a regard for us, and they have to trust and have a good relationship with us in order to say, I think my lawyer is going to help me do what I want to do, and it starts with being able to translate what they want to do and go forward.
I think as an IP attorney with an increased emphasis on intellectual property, more involvement up front, delineating what rights NASA needs to get what it wants to do done, figuring out how that fits into contractual context, just more involvement up front overall.
I think I touched on it earlier, but I think we will have to become, one, very well versed in our own government's authority, because ultimately our job is to protect NASA, the agency, and the employees from doing anything that is opposite to the authorities that we do have. But second, we do have to understand the commercial parties and what's commercially reasonable terms in order to advise our clients. And that's a dual hat, and we have to become really well versed in both sides in order to advise our clients appropriately. And the example I'll give is, for example, insurance, right? Government is self-insured. Insurance is one of those areas where we have to really understand, because we're advising our clients to work with the commercial sector, and that's like a key cornerstone of what the commercial sector does. So it's being dual-hatted like that.
Well, thank you to Lizette, and thank you to all of my panelists. We're just about at time, so unfortunately I don't think we will have time for questions, but we will all be here for a few minutes after the panel, so certainly if anyone in the audience has any questions for us, please feel free to come up and talk to us after the panel. And thank you to our audience. We hope that you've learned a little bit of information about some of your younger NASA lawyers and the legal landscape that we're currently working with, and what we're doing to change that and make sure that we're as effective as possible moving forward. So thank you, everyone.